made here now of where to find it. Yeah. Right. I just want to check that this is where the one it's in. Yeah, it is. Yeah. So this is the rights and responsibilities, and it covers the health, safety and welfare at work and the legislation governing it. And this is, well, it's important for you to know it as well. And because a lot of this regulations and things are written in law. And if you are going to be a manager, and if you are even a room leader, to be honest with you, if you're a room leader and you are responsible for a staff member under you, the book kind of stops with you from one point of thing, but and then it, as well as that, it goes, the manager is then responsible as well. So we will look at the main legislation. This is the rights and responsibilities. The main legislation covering the health and safety of people in the workplace is the Safety, Health and Welfare at Work Act 2005, amended in 2007, and was revised again on the 1st of January 2018. They change this from time to time. You know, they think they don't change the whole thing. You know, the first thing came in 2005, they just changed parts of it in 2007, and then they looked at it again in 2018 and changed, like we all do. We all look at our policies and procedures once a year. If nothing needs to be changed, we just sign off on it. But if there is, then we add an amendment if something has to be changed. It sets out the rights and obligations of both employers and employees. It also provides for substantial fines and penalties for breaches of the health and safety legislation. That's why it's so important that employers get health and safety issues right, because it's written in the law. And we all have health and safety statements, and the health and safety statements have to be visible and have to be in a public area. And so it's the Health, Safety and Welfare at Work General Application Regulations 2007, revised and updated in January 2018, in case you ever want to look at it. Employers in Ireland are responsible for ensuring all their employees receive certain basic employment rights. These rights are governed by detailed employment legislation. An employee is a person employed for wages or salary. Now, I suppose if you're doing it for nothing, you're not, well, who'd be doing anything for anything? You're not an employee. Under the employment legislation, both the employer and employee have rights. And all employers must have a health and safety statement in place. They just must, you can't open your door without it. So the employee has rights and employers have rights. A health and safety statement specifies how the organisation will implement safe practice in the workplace. It is the duty of the employer to ensure that the safety statement is implemented. In big companies now, they'd have a health and safety officer. They might even have a couple of them. And then it's the officer's job to see that health and safety are in place. Like we have, you know, since the COVID and the returning to work and things like that, we have what we call the workers' representative. And it's the job of the workers' representative to see that things are in place for the employees to keep them healthy during the COVID-19. And it's up to them then to see if things, you know, if where the PPE or gear is running out, or well, also they will say the workers' representative are supposed to point out as well to the employers if things aren't right. So under the Health, Safety and Welfare Work Act, amended 2005, amended 2007, which covered it up to 2012, and then the same act stayed in place then until the 1st of January 2018. Employers and employees and all who are involved in the workplace have a duty of care. The place of work means a place of work intended to house workstations on the premises of an undertaking and any other place within the area of that undertaking. That's to where the employee has access. So our workplace is wherever the employee is working, and that's it. And that's reference the law reform.ie. So manager conduct all work activities so as to ensure the safety, health and welfare of people at work, including the prevention of improper conduct or behaviour likely to put employees at risk. That would include things like horseplay, where you get an awful lot if you had young employees, you know, particularly apprentices and things like that. And there's horseplay going on. There can be bullying as well and things like that. Is up then for the manager or whoever's the responsibility to bring the attention of the health and safety statement, which also covers bullying, to the attention of the employees. They must design, improve and maintain a safe workplace with safe access and exits. Reduce risks and prevent accidents by implanting, providing, maintaining safe systems at work. For example, putting up signage. You know, we'll say in shops when they're after washing floors, they put up signs like wet floors. That is to prevent accidents. The site, plant, workplace, or the school or childcare facility and the equipment contained therein should be in good condition and safe. So employers, this is our duty as employers, to reduce risks and prevent accidents by implementing, providing, maintain safe systems at work. Provide information, training and supervision to ensure that safety standards are met. For example, manual handling, first aid training, etc. Provide appropriate protective clothing and equipment. Now that's very appropriate. Now at the moment I have the COVID-19 underneath that. There must be sanitizer, aprons, masks, gloves. Windows, skylights and glass partitions, excessive effects of sunlight are avoided in place of work, having regard to the nature of the work, the characteristics of the place of work. For if you know, if there's a lot of windows and a lot of skylights and it's very warm, and the thing we have here a room where it's a conservatory and things, I have blinds, I have the overhead part of it is glass, and I have blinds on it, so we can open them and close them as needs be, although we kind of have them closed most of the time. Room temperature has to be correct and at a comfortable setting for the employees. And long ago, when they don't do it anymore. I haven't seen when inspection started first. There's been an environmental officer, and she come in, she'd put a thing on the wall, thermometer on the wall, and she'd invariably tell you the temperature of the room was wrong, because it was either 1 degree too hot or 1 degree too cold. It was never right handed. Same with the water. She ran a thermometer under the water. I never had it right. It was always 1 degree too hot and 1 degree too cold. But then kind of, you know, we ended up then putting kind of thermostats and things on our heating, and that started it. So if you're outdoor places, and we're talking about schools now and settings here, but it can be any outdoor space, an employer shall ensure that when employees are employed at outdoor workstations, the workstations are as far as possible arranged so that employers are protected against inclement weather conditions and they cannot slip or fall. Now that you can bring that up when you're talking about health and safety, and you will be expected to refer to COVID-19. Because of the fact that we are outdoors a lot now. There is no way you'd have put someone out if they, like tonight, because I'm listening to it here now and it's boring. But I mean, you must have protective covers outside. Children have raincoats, children have Wellingtons, staff as well have to be protected when they're outdoors. The same during the summer, you have sunblock for the children. The staff should also be reminded to put on sunblock themselves. So the employees' obligations, this is for employees, make themselves familiar with the health and safety statement of the school or the organisation. Cooperate with employers in matters of health and safety by following procedure and use of protective clothing and equipment provided. Now that would have a lot to do, we'll say, with hard hats and building sites, or, you know, we'll say welders having to wear special goggles and things like that. They should wear them, or wearing special boots and things like that on building sites. Take reasonable care to perform their duty safely so as not to affect the health and safety of oneself as well as others. You be responsible for your own health and safety, and don't put your colleagues at risk. Report on safe conditions to a supervisor. If you think that something isn't safe, then report it to someone. And always when you report something, the person that you reported to should make a note of it, that it was reported. I should kind of, now this would be in huge settings, like you wouldn't not here with our place, but you'd say if there was huge staff or something like that, you'd say to your room leader, your supervisor, look, there's a crack outside in the seesaw and things, and it's going to crack, my child is going to fall or something. No, the person you reported should log it that yes, it was reported. If you're the one reporting it, you should insist that it's logged, because if it's not fixed and a child does fall off and a child gets hurt because it wasn't fixed, well then, and you are the one that's supervising that child in particular on that particular day, you there's no point you saying, well, I said that now to Mary last week. Mary said, I heard nothing about it. I don't remember you saying it at all. Well, you say, well, I'm sorry, but you have it logged in such a place. That is you. You have your job done. It's up to Mary, didn't have gone and said it to someone else. Undergo any reasonable medical or other assessment if requested, do so by their employer. If your employer requests you, if an employee comes in and constantly complaining of a bad back and they can't do this, they can't go down the floor with the children, they can't change the nappies because their back is bad, well, the employer has the right to say, well, no, that's fine, and we've a letter from your doctor, but I would like you to see the doctor that's attached to the setting or the school and things like that and the employer pays for it, and that person does the report, and if that happens, you as an employee or I as an employee should do what the employer asks. Report injuries to your employer immediately. The minute you get injured, you report it. No point reporting 3 months down the road. It might be nothing. You could be absolutely fine tomorrow. You could be grand. But if you get hurt at work, say it, because it's then put into an accident, the accident report form or whatever. It's even if there's something like getting something like a child hit you with a brick and you're getting a black eye, I would log it. It was an accident, but log it because you know probably your eye is going to be tomorrow. So report injuries to your employer immediately. An employer should ensure that places of work where necessary are organised to take account of persons at work with disabilities, in particular as regards doors, passageways, staircases, showers, wash and basin, lavatories and workstations used or occupied directly by those persons. So if there any new buildings or anything now set up or any business set up, they have to make allowances for people with disabilities. So health and safety during the COVID-19 pandemic. Now, exposure to COVID-19 can present a health risk to you in your workplace. You can get information, you can return to work safety. Now, we all did this return to work thing. Now, I copied this from this course we did before we came back to work. Advice for employers. The Health and Safety Authority has published COVID-19 advice for employers. There is specific advice for workplaces where, now all employers should have looked at this and gone through it. There is no occupational exposure or health risk to COVID-19. The nature of work poses an occupational exposure risk to COVID-19, such as healthcare and laboratory settings. That would only be people working in laboratories or hospitals or nursing homes. Employers are advised to follow the latest public health advice and must identify measures to mitigate the risk of COVID-19 infection, implement suitable control measures in the workplace. Now, this is where the problem is arising now, and we said this every day. If there is a case of COVID in a school, and I've known schools where this has happened, and the parents come and they tell the principal of the school, look, Johnny has been diagnosed with COVID-19, and now we're all having to self-isolate, and we all are now going to be tested, and his contacts will be closed. And the principal of the school is left in an awful quandary because the principal of the school cannot tell the parents. The HSE are the people that tell the parents. Now, I think you all probably heard in the news where a principal of a school in North Kerry, where 7 students had COVID-19.
That was my secondary school.
Sorry?
That was my secondary school, Camila. I went there.
Did you?
I did. That's the secondary school I went to.
Was it? Yeah. And you see the poor the poor man, for God's sake, he was only
I
trying to do
know,
what
it's
was right.
crazy.
It was
Yeah.
awful. And you see, if you do things like what they're doing is, and it's the same in preschools or the same in any school. If I was told in the morning a child here had COVID-19 and the parents are being tested and everything, and they've told me, and the thing, I cannot do anything. I cannot tell the parents. I can ring the HSC and say, and they'll say, yeah, we know, or yeah, we will know. I cannot tell the parents because it's a breach of GDPR, it's a breach of data protection, and it's a breach of privacy. And they are now supposed to be telling the parents. Apparently, what they do is they notify by, I think, if it happened here, they will then send me a letter to give to every parent as to what to do. But I know a school where they had COVID-19 and where the principal rang every single solitary day and they never ever came back to him, and the child stayed out for the bones of nearly 3 weeks and eventually came back because he couldn't stay out anymore because the parents didn't were afraid to send him back but didn't know, and the HSE never got onto the school, never got on at all. So when you're, it's very difficult now to know what's the right thing to do. So that's why while we have everything in place and we're doing the best we can and we're trying to stop infection coming in, but when we have the support of the HSE behind us, that's why we're in right trouble, because we've seen it happen in nursing homes and things like that. So, you know, they were talking about we did all these courses, and as employers, and we'll say principals of schools and things, we're all day doing these courses online before we started, and we had to have this done and that done, and this box ticked and that box ticked, and it's all absolutely pointless, because if we're not getting the support from the HSE, the whole thing is pointless. So even though we can be implementing suitable control measures in the workplace, if we cannot, when an infection comes in, and if it isn't worked on straight away, I feel it should be done within 24 hours. Sure, what do we do after that then? You know, we don't know how many other children would be infected. So I mean, we're in a bit of a quandary, really. So, but we have to abide by the guidelines, and that's simply it. And that's what employers are advised to follow, the latest public health advice. And that's it. And you have to do it. And you can't do anything else or you'll find yourself in right trouble. So that's the advice for employers. The advice for employees is you should follow the official public health advice and guidance. Make sure you follow good hygiene practice to protect against infections. So you'll be, as employees will be getting their information from school principals and managers, and all any of us can do is protect ourselves. So if you are out if you get COVID and you are out, you get 3 weeks paid. If you're out longer than the 3 weeks, your health and safety, you can then claim under your health and safety benefit after 3 weeks. So health and safety leave is treated as though the employee has been in employment and carries usual entitlement. So you don't lose any benefits if you are out under health and safety leave, which is you would be out under the COVID leave. Now, sometimes you'd have to be out because you'd be so sick, but some people have it, are diagnosed with COVID and they've no symptoms at all. But you're paid for 3 weeks. After that, you can get health and safety and you'll hold on to all your holiday entitlements and everything else. An employer should carry out a separate risk assessment if they are considering employing someone aged under 18. So this is health and safety and young people. It must be carried out before they get the job. There's no point in employing someone who's under 18, like in shops and things, you know, how they take on students and check that the place that you are able to cater for them. The young person should not be given the job if certain risks are identified. For example, this could mean risks that the young person cannot recognize or avoid because of their lack of experience. You know, they're too young to realize that there's any danger and things like that. As well as that, if you're employing someone under 18, there's restricted working hours. They can only work so many hours depending on their age. They can't work at all until they're 16. So, and they go on the employer's revenue tax books, and they get PRSI paid, and they get it paid at a different rate, but there's only so many hours a week that they can work. So health and safety leave during pregnancy. An employer should carry out separate risk assessments in relation to pregnant employees. If there are particular risks to an employee's pregnancy, there should either be removed or the employee should be given alternative risk-free duties. I don't mean removed like go away, don't deny me kind of that removed. They can be either removed to other duties, or if there isn't something else available for them, they can be released under health and safety leave of work. And this may continue up to the beginning of her maternity leave. And then the maternity leave, this is set out in Section 18 of the Maternity Protection Act 1994. If a doctor certifies, we'll say if you're working by night, that night work would be unsuitable for a pregnant employee, she must be given either alternative work or health and safety leave. And that's it. All right. Any questions now? You're all right? Okay. Right, roles and responsibilities are our next. God, it is bucketing. Now, so you would say the roles and responsibility of the childcare worker is to support and assist in the provision of full daycare of the highest quality in a holistic setting for children from ages whatever. That is if you're employed in a full daycare. Now, there would be different role if you were part of the wobblers and toddlers, if you were only covering for breakfast club, if you're only coming in for after school care, which covers 4 to 12 years, or if you were under the ECC sessional 2 years, 8 months to 5 years, and then it's who you report to. You report to, as a room leader, you report to your room leader. If you're a room leader, you report to the manager. So that would be thing. Oh yeah, there we are. Roles are responsible. You must be willing to work with children of varying ages, from babies to after school children. This would be now for full daycare. Perform a variety of tasks such as nappy changing, toileting, sterilising, feeding, nap supervision, engaging in play. Conduct observations of children under the direction of the room leader. Now, if you're the room leader, you would be directing the childcare assistant to do observations and refer back to you. Follow the policies and procedures of the service at all times. Cleaning, tidying, and storage of equipment and toys after use. Coordinate the implementation of activities suitable for different age groups. You would maintain the room and equipment to ensure health and safety of the children at all times. Ensure a good standard of hygiene. Now, we're experts on that at this stage. Organise material and toys to benefit of children. Support children's development, emotional, social, physical and cognitive, and carrying out activities. Attend meetings and undergo training as required. Be aware of child protection procedures and advise managers should you have any concerns about a child. Maintain strict confidentiality. Any breach of confidentiality about children or their families will constitute gross misconduct. Now, this is here now, look, roles and responsibility would reference the confidentiality. So that is vital, really. Maintain, and if you write a piece on that, make sure you bring that in. Maintain strict confidentiality, and any breach of confidentiality about children and their families will constitute gross misconduct. And every setting has their own rules and their own policy on confidentiality. Perform other reasonable and relevant duties and may be assigned from time to time. Now, here's confidentiality. All businesses, not just childcare, should have a confidentiality policy and should be read and adhered to by employees. Employees usually sign confidentiality contracts before commencing work. The education and care service protects the privacy, dignity and confidentiality of individuals by ensuring that all records and information about individual children Their families, educators, staff and management is treated with discretion and kept in a secure place and only assessed by or disclosed to authorized people. So that's very important really when you're doing that, refer to that little piece here. You know, it protects the privacy, dignity and confidentiality of all individuals, just not the children, the children, but their families, the other staff members, or anyone that it has dealings with the children. How do you maintain confidentiality in childcare? Ensure recording information and photographs of children are kept secure and may be required at any time by the child's parents or guardian. Ensure families only have access to the files and records of their own children. Treat private and confidential information with respect in a professional manner. So, you know, well, we know that anyway, you know, we keep the children's files for their observation, but you wouldn't be, why would you be showing them to someone else? And the thing about, we'll say, cameras, we all have our own cameras in the schools and they're just for the school only. The minute you are finished with those photographs, we take photographs for observations and then they're downloaded and printed off and put in whatever we put in our journals or the child's observation sheets or whatever. Those pictures must be deleted from your camera. You've no more use for them. You took that picture for a reason. The reason is now done, completed, get rid of the photograph. And that's it. Again, we're under GDPR, data protection, everything else. You'll be demented from me saying this. So maintaining and breaching. Childcare programs maintain confidentiality on a need to know basis. This information is shared only when it is necessary. This is important, especially when there are specific health and safety concerns. Maintaining confidentiality also builds trust in childcare programs. So our next module is called Social, Legal and Health. And we're going to be talking about this on a need to know basis because there is a case study in it that's quite interesting. But this now it would apply, we'll say, in a really big setting and where there's a lot of staff. There is no need for the staff in another room to know about a child in another room if they have nothing whatsoever to do with them. If you're in a smaller setting where all the staff work with the children together and that staff and a staff member may be working with that child tomorrow or next week or something, there's things they may need to know. Otherwise, there's no point. There are certain things that managers would be told that no staff member need know at all. It's none of the staff members' business. We'll say things like to do with, we'll say, any sort of medical problems, or from the parents' point of view, you know, they might tell you, look, his granny will be bringing him certain days and because I have this medical problem. Nobody else needs to know that. That really is between the manager and the parent. Now there would be things like, we'll say, barring orders, or where a parent is not allowed to collect a child from school. Now, if there is the only one that need know about that are the people dealing with the child in the room. But if different staff are taking people to the door on different days, we'll say 1 week it's me and the next week it's Caroline or something, then we would need to know that if whoever the barring order is against is there, the child is not supposed to go with that child. But that is it. There is no reason. We don't need to know why the barring order is there. All we know is there's a barring order, but we don't need to know why. It's none of our business. So breaching confidentiality. A breach of confidentiality occurs when confidential information is not authorized by the person who provided it or to whom it relates, putting said person in danger or causing them embarrassment or pain. Now that's taken from a legal document because you know about the terminology. It's not a breach of confidentiality if the information was provided on the understanding that it would be shared with a limited number of people or where there was consent to the sharing. So where it breaches it, if you're telling something to someone and that there was no need for that person to know, or it would cause embarrassment to the person you're talking about, or cause them hurt or pain or anything like that, you have no right to be breaching that confidentiality. But if a parent tells you something, they said, look, you can tell the others that as well, then that's fine. You're not breaching confidentiality there. Now, Confidential information may only be shared without authorization from the person who provided it or to whom it relates if it's in public interest. Now, sorry, I'll just take a drink again. For example, where not sharing it could be worse than the outcome of doing so. So the decision should never be made as an individual with the backup of managers who can provide support and sometimes ensure protection. So the three critical criteria for sharing information without consent or overriding refusal to give consent are: where there is evidence that a child is suffering is at the risk of suffering significant harm; where there is a reasonable cause to believe that a child may be suffering or at risk of suffering significant, I repeated myself there. Well, no reasonable cause and evidence are two different things, I suppose. And to prevent significant harm arising to children and young people or serious harm to adults, including the prevention, detection and prosecution of serious crime. Sorry about that. If you're there and you're doing it, you breach confidentiality to protect a child because you're afraid they're in danger. Well, you haven't broken the law because you're doing it in the best interest of the child. Or if you are doing it you have reasonable cause to believe that something might happen to this child, you are doing it for the right reasons. We will be discussing that as well in the next module. Then you're not breaching you're not breaching confidentiality, you're not breaking the law. If it's a case a mother comes in and she tells you something about something that's happening to her, and that the husband, she's all black and blue, or vice versa indeed, or the husband comes in and the wife is after beating the life out of him or pulling a knife in him or whatever, and he's, don't tell now, don't tell. Now, I think, and it says here, to prevent significant harm arising to children and young people or serious harm to adults, including prevention, detection, persecution and prosecution of serious crime. I just think there you probably would, if you were to, would say, tell a member of the family of what the person told you. I don't know about going to the guards. I don't know what the outcome would be if you did go to the guards about it, because the other person that probably was being battered would probably say, no, not at all, I fell down the stairs, I never told her, something like that. But in the interest of making sure that someone isn't suffering more harm or something like that, I think there you'd have a right to breach confidentiality. And I suppose the thing about it is if someone comes in and tells you something like that and says don't tell anyone, you'd have to say, look, I cannot keep this to myself because something might happen. So if you don't want me to talk to somebody about it, then you don't tell me. You know, and it's the same with say someone might, you know, how a child will say, I have a secret, but you're not to tell anyone. You can't ever say to a child, oh no, I won't tell anybody, because we are bound by law now to, in the interest of the child's safety and things like that, to report any suspicions we have to whoever is the person in school that's in charge of that. So that's confidentiality and breaching confidentiality. Sorry, no. Okay, are we all right there? No. I'm just checking down along now. We've confidential. Oh, the next thing now is equality legislation. Well, this is interesting as well, and it's very important in our field that all our children and parents are treated equally. Now, equality legislation in Ireland comprises of the following acts: the Employment Equality Act 1998 and 2004 amended, the Equality Status Act 2000-2004, and the National Disability Authority Act 1999. That covers that. The Employment Equality Act 1998 came into operation in October 1999 and replaced the Anti-Discrimination Pay Act 1974. the Employment Equality Act 1977, and it was amended by the Equality Act 2004. Now, you don't have to be giving any of this, girls. It's just that I have to give it to you. They are known together as the Employment Equality Acts 1998 and 2004, and they cover the following aspects of employment: advertising, equal pay, access to employment, promotion or regrading, dismissal, as well as other issues. The Acts of 1998 and 2004 also promote equality, prohibit discrimination, prohibit sexual harassment and harassment in general, require appropriate measures for people with disabilities in relation to access, participation and training in employment. It covers all that, the Equality Act. These kinds of discrimination are outlawed, whether by an employer, an employment agency, a trade union, a professional body, a vocational trading body, or a newspaper advertising jobs. So the Act outlaws discrimination in a wide range of employment and employment related areas. These include recruitment and promotion, equal pay, working conditions, training or experience, dismissal and harassment, including sexual harassment. The legislation defines discrimination as treating one person in a less favourable way than another based on any of the following 9 grounds. Now, you cannot discriminate under gender. This means man, woman, or transsexual. Civil status includes single, married, separated, divorced, or widowed people, civil partners and former civil partners. Family status just refers to the parent of a person under 18 years or the resident primary care or parent of a person with a disability. Sexual orientation includes gay, lesbian, bisexual, and heterosexual. Religion means religious belief, background, outlook, or none. Whatever your religious belief, you can discriminate. Age does not apply to a person age under 16. You cannot discriminate someone under 16 because under 16 there are no laws, we'll say, governing employment because they're not supposed to be employed, and so you can't discriminate against them. Disability includes physical, intellectual, learning, cognitive, emotional disabilities, and a range of medical conditions. Race includes the race, the skin color, nationality, or ethnic origin, or religion is above, and the membership of the traveling community. Now, that was added very later on, membership of the traveling community. That was one of the last things. You cannot discriminate on someone because they're a traveler. So what is discrimination? So discrimination is defined as less favourable treatment. An employee is said to be discriminated against if they are treated less favourably than another and has been or would be treated in a comparable situation in any of the above 9 grounds. So it is if they're treated different from anyone else because they fit into any of the previous 9 grounds that I mentioned. To establish direct discrimination, a direct comparison must be made. For example, in the case of disability discrimination, the comparison must be between a person who has a disability and another who has not, or between persons with different disabilities. Indirect discrimination occurs when practices or policies that do not appear to discriminate against one group more than another actually have a discriminatory impact. It might not appear as if they're discriminating against them, but in actual fact they have. We'd say that would say the traveling community, how they would not be left into certain hotels for weddings and functions and things like that, and the hotel would always have an excuse, something like, you know, oh, we're booked out, or no, sorry, you know, we've functions on, and it turns out then that there's no function afterwards. Clearly then they were discriminated there. It can also happen where a requirement that may appear non-discriminatory adversely affects a particular group or class of people. So disabilities, employers are obliged to make reasonable accommodation for staff with disabilities. This includes providing access to employment, enabling people with disabilities to participate in employment, and including promotion and training. Pregnancy-related discrimination is discrimination on the grounds of gender and includes recruitment, promotion, and general conditions of employment. Women who are pregnant or have recently given birth are also protected under maternity protection and unfair dismissal legislation. Equal pay. Employment equality legislation provides for equal pay for like work. Like work is defined as work that is the same, similar, or work of equal value. So it would be if a woman is paid less than a man for doing the very same work, that's discrimination. It is one of the terms that must be part of the contract of employment as a result of laws passed by the Dáil. So that should be in your contract of employment. Really, well, I don't know anyone that puts it in that you get the same. Well, I suppose it would be if you were in a situation where there was an equal workforce of men and women. A claim for equal pay can be made in any of the 9 grounds listed above. Harassment, including sexual harassment that is based on any of the 9 grounds, is a form of discrimination in relation to conditions of employment. Bullying at work, which is linked to one of the 9 discriminatory grounds above, comes under employment equality legislation. You'll be bullied at work for your colour, your religion, your sexual orientation, anything, and that is, well, bullying is against the law, but it's stated in the Discrimination Act. Victimization. Under employment equality legislation, you are protected against victimization if you bring a claim or are involved in a complaint of unlawful discrimination against your employer. This means that your employer may not penalize you by dismissal, unfair treatment, or an unfavorable change in your conditions of work. Sorry. If you bring a case against your employer for victimization and the case is upheld, then, well, obviously you can't be discriminated against. Are treated unfairly. The Irish Human Rights and Equality Commission and the Workplace Relations Commission are separate organisations that work to ensure equality at work. They're the organisations that work. The Irish Human Rights and Equality Commission is a statutory body set to provide information to the public on human rights and equality legislation. It can, at its discretion, provide legal assistance to people who wish to bring claims to the Equality Tribunal. So there's a booklet called Your Employment Equality Rights Explained, and you can get it on that website. You actually can quote that website on your reference. And when we're finished, I'll send you on. I've been taking down the references of where I got all this information, and I have couple of pages of them. So what I'll do is when I have them done, I'll send them to you, I'll email them to you, and you can take out the relevant ones and put them on your references at the end of your assignment. And of course you will reference it in, I don't know what you want to reference it now, seeing we don't have classwork or class notes. I don't know, I suppose tutor notes or or PowerPoints or something. The Workplace Relations Commission is the place to bring a discrimination claim under those acts using the online complaint form available on workplacerelations.ie. It investigates or mediates claims of unlawful discrimination under equal legislation. So you actually can bring it online. You just go in, download the form, fill it out and send it off. And there we are. So that is the equality legislation. Now the next one is, and it's my last one for the night, but it's covering where are we? It's under pay. Here we are. Now this is covering a whole bit, but I'm putting it under the one thing because there's only a few things in each. Oops. I'm going down to the bottom, sorry. Now, this is about, we're now going to cover here. Now we're right down at the very bottom of, or not the bottom, page 7, down the last section. We're going to cover union representation is down at the bottom of this slide here. Then we're going to talk about pay. We've already spoken about pay when we're talking about contracts and things, but I'll do it again and bring in the minimal wage. Now you will be expected to bring in the minimal, what the minimal wage is. We'll cover annual leave, what it is, and about leaves, about maternity leave, parental leave, and the new one, paternity leave. So we'll do the minimal wage. We did it before. quick run through. Since the 1st of February 2020, gone, the wage is €10 per hour set out on the National Minimum Wage Order, and wage rates are solely based on age. Well, see rate you see below. You go on that link I gave you there, and they give you all the rates. The national minimum wage does not stop an employer from offering a higher wage. So there's an increase in minimum wage in 2021 in January. It's going to go up by 10 cents from 10.10 to 10.20. So here what you have to what you expect when you're paid. You're expected to get a pay slip. All employees are entitled by law to a written statement of salary. This statement is called a pay slip. So you go on to that link I gave you, and you want to find out about pay slips, you go into that, but you don't want to find out about it. Minimum rates of pay. Under the National Minimum Wage Act 2000, most employees are entitled to a minimum wage. There are certain circumstances, if you remember we're talking about it, they have to do if you were working for a member of family, they don't have to get a minimum wage like a spouse or a son or a daughter. It's not a requirement by law. So employment detail summary, which was known as the P60, as you know, there's no more P60s. Information about the new employment detail summary and the tax summary when you leave a job. They were the P60 and P45. You don't get them anymore as an employee. The revenue, the employer fills out a form on the revenue line, and the revenue have it. And the revenue sends all the details to your new employer. So when you are regularly paid late, supposing the agreement was your contract to be paid every Friday into your bank account or by cash or whatever the arrangements were. If your employer is regularly late when paying your wages, then there are procedures you can use to enforce your legal right to your pay. You win that link as well, and there is what you do and who you report the employer to. Leaving work without being paid. If you lose your job, you have certain rights and entitlements, including the right to be paid for work you have done. So then you go on to the same link that I gave you to find out about what you do to get your wages back. Taxation of benefits from employment. Employees can get certain benefits in addition to their salary and wages. Some of these benefits are taxed. This document provides information how such benefits are taxed. Go back to that link as well, and it tells you. Now, if you get a bonus, if people get bonuses and it's put into their wages, that is taxed. Some of the big companies don't give money anymore. They give vouchers. You know, and so you might get a voucher for, I don't know what. I remember Grace one time got a voucher. She bought a Fitbit or something out of it. And then you don't have to pay tax. So they get around it that way. They give vouchers. Maybe they find out what your interest is or something, give you a voucher for that particular thing, and you can spend it whatever you want to. And it's legal. It's not illegal. It's a legal way of you getting benefit in kind, but it's not money, so it's not taxed. Annual leave is defined as a holiday during which you're entitled to receive your usual wages and your usual payday. Other types of leave that you may take throughout the year include maternity and paternity leave, carers leave, public holidays, but these do not affect your annual leave rights. Your employer has the right to refuse an annual leave request. Must take into account your family responsibilities, your right to take opportunities to rest, and your right to be informed of any changes to your annual leave at least a month before it occurs. Now, if you booked a holiday, we'll say for next April, and well, the employer has to tell you if you can't take your holiday the month before that by March. All full-time workers in Ireland are entitled to receive 20 paid holidays each year, although many companies include more than this within their contracts. And all that again depends on your contract. Your employment contract with your employer should set out exactly what you're entitled to, although this can be more complex if you work part-time or take sick leave during the year. Your contract should also tell you whether you are entitled to carry unused holiday days through the following year, as this is not a statutory requirement. Some companies want you to have your holidays taken by a certain date. And that it prevents crossover of holidays because it messes the whole thing up. Annual leave should never be used to cover periods of time when you are unable to work due to illness. And if you are ill while you are on annual leave, you can visit your doctor, obtain a cert, and retain your annual leave allocation for a later date. Now, we'll say if you wanted a day off to go to a wedding, that's a different kettle of fish. You could have three options. It could be a case of a deducted day's wages, make up the day, or take it out of your holidays. Since the Workplace Relations Act 2015, and that was amended in 2015 to change the following have occurred. An employee will continue to build up annual leave entitlement while they are on sick leave. If you're out sick for a month, you continue to build up your sick leave because you're sick, or your leave, your holiday leave. If an employee is unable to take the annual leave because they are ill, they will be entitled to an extended carry-over period of 15 months after the leave year in which you used this holiday. If it is the case that you were out sick for a long time and you cannot take it within the required time that your employer has laid out or in the contract because you were sick, that can be extended to 15 months. After the leave year, like add on 15 months. When the employee leaves their job, they must be paid in lieu of annual leave that has been accrued but not taken due to illness. So if you leave your job and you haven't taken your holidays, you get your wages for the days you've worked plus your leave. If this falls within the 15-month period after the end of the year in which the annual leave was accrued. 4 weeks leave, 20 days if you work 5-day week, or 24 if you work a 6-day week. I don't think anyone works 6 days anymore, unless you're self-employed. This is in addition to legislation which states that your employer is legally required to ensure that you have at least 24 consecutive hours rest in each period of 7 days. So nobody should work 7 days. That's, you should have a day off to rest. There are 3 different ways to calculate your annual leave entitlement. Oh, look, that's all about the hours in the leave year, April to March, and 34 work, and employee may be entitled. You don't have to give us this at all when you fill it in. An employee may be entitled to annual leave equivalent to 1/3 of a working week for each calendar month which they worked at least 117 hours. I'll leave you to read that, ladies. The reason I put it in is I thought you might find it interesting. To what about annual leave and things like that, and what people's entitlements are. Now, an employee may be entitled to take annual leave equivalent to 8% of the hours worked in the leave year, subject to a maximum of 4 working weeks. And legally, an employee can use whichever one of these methods gives a greater entitlement, and can include all hours worked, time spent in annual leave, maternity leave, paternity leave, force majeure leave, adopted leave, or for the first 13 weeks of carers leave. That has to be included in your annual leave. If an employee has worked for at least 8 months, they will be entitled to an unbroken period of 2 weeks annual leave. So if you work for 8 months, you're entitled to 2 weeks of annual leave. For part-time workers, annual leave is generally calculated using method 3, which is the 8%. So what they do is, in part-time worker, you add up your hours and you take 8% of it. You pay them for the 8%. Where an employee works part-time for part of the year and full-time for another part of the year, the annual leave allocations can be calculated separately. Now, remember, some companies may give their employees more than 20 days holiday leave per year, but that would be in your contract. Now, annual leave when you leave your job. If you decide to leave your job, you will be entitled to receive payment for any outstanding annual leave you have built up, but not taken, as well as any public holidays due to you. There is no other circumstance which you can be paid an allowance instead of taking annual leave you're entitled to. So you are entitled to annual leave if you leave your job. You're entitled to be paid. There's no point in saying, well, I hear now when you leave, and I heard you moving. I should look, I'll give you a washing machine instead. For your new house and things, you're moving to a new job. No, you take your holiday money and that's it. You can buy your own washing machine. Maternity leave. Now this might be, this is probably important to a lot of you there now. Paternity leave. Parental leave entitles parents to take unpaid leave from work to spend time looking after their children. Since the 1st of September 2020, both parents can take up to 26 weeks parental leave. Paternity leave is specifically for new parents other than the mother in their first 6 months. Now, maternity benefit is paid for 26 weeks. Maternity benefit is a 6-day week payment which covers Monday to Saturday. Sunday is not treated as a day of entitlement to maternity benefit. At least 2 weeks and not more than 16 weeks of leave must be taken before the end of the week in which your baby is due. So you must leave even you're feeling absolutely fine and say, oh no, I want to work right up until to the end. No, you must leave 2 weeks before, because bosses don't want you having babies on the floor unless you are self-employed. Then you can work up to an hour before you go into labour. If you are pregnant and your employer has no work available, this is during the COVID-19 now, you should have this now, and it's maternity leave now we're talking about here. You should apply for the COVID-19 pandemic unemployment payment, the PUP. This applies both when your due date is within 16 weeks or is more than 16 weeks from the last day of your employment. So if you are pregnant and your boss has no work for you due to COVID, you are entitled to claim for PUP up to the time that your maternity leave kicks in, and then you come off PUP and then take your maternity leave. Submit your maternity benefit application as normal with your maternity leave, so that's important. To start, when you're applying for your PUP, you let them know as well that you'll be taking maternity leave so that they can calculate the two payments. And if you are still in receipt of COVID-19 pandemic unemployment payment when you are due to begin your maternity leave, you must close the PUP and move on to your maternity benefit. Now, if you're entitled to the full rate, you'll get $245 a week for 26 weeks. If you're already on certain social welfare payments, you may get half-rate maternity benefit. So they may cut your maternity benefit if you are getting a social welfare payment. Maternity benefit is a benefit for employed and self-employed people. Now, it's only recently the self-employed people started to come underneath the barrier of getting maternity benefit. And self-employed who are on maternity leave from work and covered by social insurance by PRSI. And the week your baby is due, if your baby is, say, is due on a Wednesday, October 28th, the latest date for the start of your maternity leave is Monday, the 1st of October 2018. Your maternity leave always starts on a Monday. You can't be saying to boss, look, I'll wait till Thursday. You won't. You wait until either the following Monday or the Monday before. And that has nothing to do with your boss. That has to do with calculations in the Department of Social Protection. You must start your maternity leave before your baby is due, obviously. You must start your leave at least 2 weeks before the end of the week in which your baby is due. So 2 weeks again before your baby is due. You must not start your leave earlier than 16 weeks before the end of the week in which your baby is due. So you can go on maternity leave 16 weeks before your baby is due. You cannot go on maternity leave 17 weeks or 18 weeks before your baby is due. At a minimum, you must begin your maternity leave on the Monday before the week your baby is due. And that's what I'm saying. So if your baby is due on a Wednesday, you start your maternity leave on the Monday 2 weeks previous. All this has to do because of social protection and their computers. And look, they're a law to themselves and a mystery to all of us, so we let them at it. If your contract of employment ends within 16 weeks of the end of the week in which your baby is due, Jesus, I have you totally confused, you will be paid maternity benefit from the day after your last day of work. So if your contract ends within the 16 weeks before you can claim your maternity benefit, you will be paid your maternity benefit from the last day of work. So when your paid maternity benefit ends, it is possible to take 16 weeks of unpaid maternity leave. So you can then, once your maternity leave is up and you didn't want to go back to work, you can take 16 weeks of unpaid maternity leave. You will not be paid for this, but you will get credit on your PRSI credit for the week you're off, but you won't get any money. Now, if you're self-employed, your doctor must certify your maternity leave. He gives you a letter and you send it off. It's called an MB3 medical certificate. You send that off and, well, hopefully that's it. Premature births. In the case of a premature birth, maternity benefit is payable for an extra period after the end of 26 weeks. The additional period will commence at the end of the standard 26-week period of paid maternity leave. So the additional period to be added will be the number of weeks from the baby's actual date of birth up to 2 weeks before the expected date of confinement, which would have been the 37 weeks of blah, blah, and which point the current 2016. That means if your baby comes early, you can claim maternity benefit early. So if it is born prematurely, you should inform maternity benefit section enclosing written confirmation from your doctor of your PPS number, the date your baby was born and your original due date. And then stillbirths and miscarriages. So if you experience stillbirth miscarriage anytime after 24 weeks of pregnancy, or where your baby has a birth weight of less than 500 grams, you are entitled to 26 weeks of maternity leave if you are covered by social insurance. Now, they stick rigidly to this, and I'll tell you, funny thing, we were on discussing this here at home. Maeve, it's a midwife in CUH. If you have a stillbirth, and it's, we'll say, before the 24th week and the 23rd week, you won't get anything. You get nothing. They stick to the 24th week of gestation, which is very unfair. And as well as that, well, I didn't know about the birth weight, but if it's at least 500 grams or on or after 24th week, you can cover your maternity benefit. Otherwise, you get nothing. Maternity benefit after stillbirth or miscarriage, you send a letter from your doctor with the maternity benefit to the maternity section. In the letter, you should include the date of the birth, the expected date of birth, the actual date of birth or miscarriage, and the number of weeks of pregnancy. So paternity, we're talking about paternity leave now, is a legal right your employees can use when they have a child. This means important area of employment law. So it is a right, so it's an important thing. It's an important piece of legislation. Paternity leave entitles employees to take time off to support their child in the period shortly after its arrival. The result is that fathers or the partner of the child's mother can take time off from work to be with their family. Paternity leave legislation states that relevant parents can take leave when a child is born or adopted. The legislation defines a relevant parent as the father of the child, the partner, who is a spouse, civil partner, or cohabitant of the mother of child, the parent of a donor-conceived child. For an adopted child, a legislation defines a relevant parent as the nominated parent in the case of a married same-sex couple, the partner of the adopting mother, and a man adopting alone. The nominated parent in the case from, in the marriage of a same-sex couple. If they're the same sex, one of the parents would be nominated as the adopted parent and would qualify then for leave. Oh no, we're talking about paternity leave. 2016, they have an entitlement to take 2 leaves paternity leave from their employment. And it's a statutory right. And it came in September 2016. It is not affected by how long staff has been working for the boss or how many hours they work each week. If more than one child has been born, your employee's statutory right remains the same. Fathers of twins, for instance, will still just have the statutory right to take 2 weeks paternity leave. So if you have twins, says, oh my God, your boss and saying, well, I have twins, I need 4 weeks. You won't get 4 weeks, you'll get 2. When does paternity leave start? Anytime in the 26 weeks after the birth or adoption of the child. That's your employee. I'm looking at it from an employer's point of view. Must provide a cert from the mother's doctor stating when the baby is due, stating when the baby was born, so that he can apply for leave. If it's a case of adoptive leave, the employee must provide a certificate of a placement of the child. Employers must keep records of employees' paternity leave for 8 years. So if you adopt, if they adopt a baby, he presents a certificate of placement of the child of adoption. And employers must keep records of employees' paternity leave for 8 years. And I would imagine it applies also to maternity leave. We keep everything for at least 7 years. Your employee must notify you in writing, that's me, my employee must notify in writing that they plan to take paternity leave and specify the dates 4 weeks before they take it. Like maternity leave, when it comes to payment during maternity leave, employers have no obligation to pay employees for its duration. Paternity leave comes with associated state benefit that Department of Employment Affairs and Social Protection. Now, employees they cannot take, we'll say, their paternity leave in 2 blocks, like take a week now and a week next month. They have to take the 2 weeks together. So they will need, have I covered this already? Once your employee informs you from the boss intends to take paternity leave, they produce a certificate when the baby is due or when the baby is born, or in case of adoption, when they got the baby. Yeah, we covered that. Parental leave for parents of eligible children will increase from 18 weeks to 20. It has increased from 18 weeks to 22 weeks last September. Last September, 12 months now. It was 18 weeks, now they take 22 weeks. So from September 20, it will go to 22 weeks to 26 weeks. So from last September now, people can take parental leave for up to 26 weeks. Parents of children under the age of 12 will be able to take 26 weeks unpaid leave from their job, and but at the thing it's capped at 18 weeks. But from last September it went up 26. So the conditions of leave are defined by law and within the EU as well. And they adapt leave to the needs of parents and employers by granting leave on a full-time or part-time basis and piecemeal or in the form of a credit time credit. That means you can take leave rather than taking, we'd say, 4 weeks holidays and one go and say, no, I'll take a week now and I'll take a week in 3 months' time and I'll take a couple of days, then you can do that. But as long as it's agreeable by the employer. An employer can postpone leave for justified, they have to have justified reasons. And workers wishing to take parental leave must give notice to the employers. The period of notice is written down in law. Generally, it's between the employers and the workers themselves when they want to take leave. Now we're going to talk about trade unions. A trade union is an organisation formed to protect the rights and interests of the members it represents. It is an employee in a particular industry. A trade union can be an important source of information for employees, provide employees with protection on employment matters, negotiate with the employer for better pay and conditions. A trade union must have a negotiating license in order to negotiate on employee wages and other conditions of employment. Like I couldn't in the morning now decide I was setting up my own trade union and that's it. You have to get a license. Employees have a right, it's set down in our constitution, to join a trade union. You have the right to join the union of your choice and the right to leave a union. You cannot be dismissed from your job because you're a member of a union. There is no legal obligation on an employer to negotiate with a union on behalf of an employee member unless previously agreed. This does not prevent a dispute about trade union recognition from being a lawful dispute. Now, the Irish Congress of Trade Unions is a single umbrella organisation for trade unions representing a range of interests of ICTU members in Ireland, Northern Ireland. ICTU, they run websites, and if you wanted to have a look, it's called unionconnect.ie to facilitate people to join a union. Now, some trade unions, in particular Impact and SIPTU, have been active of late within the early childhood education and care sector. Now, this is what you would be giving us here under union representation. Some trade unions, Impact and SIPTU, have been active of late within the early childhood education and care sector. They have held meetings and have talked with a range of organisations and individuals about the potential to organise within the sector. Now, any of us that are involved in this know that this is going on. Both unions agreed with the analysis of Early Childhood Ireland that the problems of low pay and insecure employment conditions result from a funding model that is outside the control of providers. That means that as providers, managers and owners and boards of management, we have no control over the pay or the insecurity or anything because of our funding comes from the government. We've nothing. We have to take whatever money we get from the government. It would be a different thing if we'd say if we were running our own businesses and parents were paying us and we then could, well, we set our own rates and everything like happened before the ECCE started. So it's out of the control of providers, where government in effect sets the rate for supporting preschool with inadequate funding and where parents cannot afford to pay more than they already are. These trade unions seem to be taking different approaches within the sector. SIPTO have worked up a Big Start, it's called the Big Start campaign, and they are rolling out around the country calling for greater investment in childcare. Impact have teamed up with ACP, which is the Association of Childcare Professionals, and held regional meetings inviting people in the sector to attend. You see, this is what's going to happen now. There's going to be two. There's going to be the Big Start by SIPTO, and then there's going to be Impact. And you see, if you have a workforce and they're joined in different unions, they actually use their effect when they come to negotiating with the government. So I just don't understand why they're not trying, why it isn't just one union. At the moment in Ireland, and this is something what you need to know and write down about. At the moment, the childcare sector neither do the SNAs have, I mean, do the SNAs, I don't think they have their own union, but I stand corrected on that. The childcares, we do not have a union. We have people that represent us, and they would be the Association of Child Professionals, the National Community Forum, Early Childhood Ireland. Now that would be the one we'd mostly familiar with, and that most childcare providers in Ireland are members of. The National Childhood Network, PLAY. Now PLAY is, I've written down here, PLAY and CHASUS. PLAY is a response to our Organisation for Economic Cooperation and Development, OECD, International Early Learning Study. So they are affiliated to what we were talking about earlier, OECD. And then CHASUS is the voice for independent early learning and care providers in Ireland, working on behalf of early learning and care providers to bring constructive reform to the sector and ensure that sustainable quality services are available to parents and children throughout Ireland. So they're the organisations at the moment that are acting on behalf of childcare workers, and that go to the government with their pre-budgets, with their representation. Now, obviously, they're not very good at doing it, saying we got nothing in the last budget. And they don't seem to take a whole pile of notice of them. But they generally make their case to the government and on our behalf. So that's it, ladies. Believe it or not, we have covered everything tonight that I wanted to cover. Does anyone have any questions about anything? No, you're fine. Okay, so what I'm going to tell you.
Is that everything, is it?
Yeah, we're finished now tonight.
No, it's not. That's just section 1.
It's 10. No,
that's everything from section 1, isn't it?
Oh no, we're way beyond section 1. We're
no, but that's everything covered in section 1.
Section 1 is all finished.
Yeah.
We finished section 1 because we spoke tonight now about the practice interview and things like that. I'm going to send you out A4 information tomorrow about, listen to me, you just glance through it about the interview. I'll be in touch with you about practice interview and then reflect on the experience, and you'll do your feedback, but we can do a quick that. So we've section 1 covered completely. I will talk to you next week about we've section, isn't it section 1? So hold on a minute. Or is it section 2 we're looking at, ladies? I'm trying to find my book. Section 1.
Section 1.
Right, sorry. Section 1 is general work related, pay, salaries. Yeah, section 1. We've all section 1 now done. That's done, dusted. Section 2, we've a good bit of that covered as well. We have, because all the audit has, we've that done. Your CV and personal statement, career plan, the short, medium, long-term goals, challenges, education and training. We covered that on the 8th. You're in the middle of your task, or nearly finished it. There's the letter of application that was covered on the 8th. We were talking about websites and things like that. You'll be doing that at the end as well, but how to find website. Tonight now we spoke about the interview, so we have that spoke about. We're after covering here about the contracts. I gave you PowerPoints on contracts. We've that done. And and then how you draw up a contract with wherever you're doing your work experience there. Next week we will talk briefly about written communication skills such as report writing and form filling. That's simple. That'll only take a couple of minutes. We've tonight now covered about technology on emails, fax, SMS, Skype. We covered and all that. We covered about working teams and about the effective listening. We'll still discuss it the next night about working teams and effective listening, and about non-verbal communication, body language. I'm sure Adrian is going to be doing that with you anyway. Now your work placement. We've that done. That's finished. Work placement is finished. That's up to you. We've that covered work placement. And now the last thing left to do is reflecting on work placement experience and future planning. This will be written up, this section, after you have finished your work experience and you have all your entries done. And then it's done and dusted. It's not particularly long. You know, one of the things that I'll have to go over with you is about setting up your own business. That's a new thing now. Where did I see that? Say the very last thing here: facilitate the learner to invest the availability of finance in the event of setting up their own business. About what you have to do, what entails. So that's a new thing. We haven't had this before, so I'll have to do that with you. And apart from that, we are then done. But we will have next week, and we can do it the following week as well. We'll talk next week, and we'll probably come back the following week as well to kind of finish off. And sure, we can organise maybe an hour here and there. Then if you're stuck, is that all right with you, ladies?
Yeah.
Yeah. Yeah.
Can
No,
I ask one question,
you can,
John, if you don't mind, please?
Yeah.
Do you know in section 1 where you're doing the needs and the gaps?
Yeah. Yeah.
Like, for every need, there's going to be a gap, and for every gap, there's going to be a need. Is that right?
Well, there would be. There would be. Show me where exactly now is this?
Yeah. This is
I know. I remember doing
section 1. You know, identify.
Yeah, I know. I remember doing it.
Identify relevant needs.
Here it is. I possible present corruption, for example, needs and gaps. And well, you see, needs and gaps. You see, do you know something that kind of it means the same thing? To be quite honest with you, if there's a need, there's a gap. There is, And what you have to look, this is a need and this is a gap. What would I have to do to finish that? Do I have the qualification already to finish that? Because it's in relation to career opportunities. And do I have a qualification at the moment? If I haven't, what do I have to do? I will have to take further education, or I will fill that gap when I have completed my level 6. You know, that sort of thing. So a need and a gap really is the same thing. I have to make things right. All right.
That's fine. Yeah.
Any other questions, anybody?
Do you know the CV that you want, Joan?
Yeah.
Do you know the way we done one for Adrian, and that was in like a presentation?
Yeah.
Do you want it in a presentation, or do you want it a different way?
No, whatever way. No, you will have, when you hand me up your CV, it has to be like you'll be handing it up to a job. You know, it has to be on Microsoft Word.
Oh, right, yeah.
So what you'll do is, what I want you to do, girls, when you get a chance, would you ever put your CV up online so that I can read it, send it to me via email, and so that I can look at it? Because if I'm going to be doing an interview with you, I need to have a look at what your CV is. All right.
What's the detail again, Joe?
Yeah. Sorry?
Do we have to put in the certs with the CV?
Oh no, you don't. What you do is you'll just mention the CV, like you'll mention what your qualification is. You don't bother including it. You will mention you'll mention what courses you have done. But that's all you have to do. Do you see? Even if you're going for an interview, sure, even if you're applying for a job online, they wouldn't look for certification until they might ask you to bring it to an interview, or they might ask you after the interview. So all you do is you give me whatever, 1 or 2 pages or whatever your CV is, make it short and sweet. And whatever you're going to be handing me up, you'll be including your CV in that. Have it done. Give me that, and sure, when it's done, when you just print it out then and have it put into your work experience work. Now, what I'm going to do is, well, ladies, is I won't do it now for maybe a week or two because I need you to get it. I am going to send you an email and I am going to break down exactly the way I want you to lay out your work experience folder. You know, kind of up in the front, you'll put your brief inside. After the brief goes this, this, and this. I'll even tell you where to put in the divider. Put in divider, written on it, whatever, section 1, and then whatever goes in section 2. So I'll break it down so that everything follows as it should follow. And it'll make it easier for you to put it together.
Okay.
All right?
Yeah.
Is that right?
Yeah,
Yeah,
brilliant. Thank
perfect.
you.
Yeah.
Okay. All right.
Great.
Yeah.
Okay. Right, ladies. So I'll send these off now on tomorrow, hopefully the PowerPoint, and you'll get the recording then. I usually listen to it over the weekend. I have to cut chunks out of it, like bad language and things like that, and huffing and puffing. And so you'll get that next week. Hopefully now, I haven't done it last week. I had to do an awful lot of huffing and puffing and going on and cutting because the language is only choice and parts of it when my microphone wouldn't work. But so I usually kind of edit it over the weekend. That's why you get chunks. All right. So I'll send you the PowerPoint anyway tomorrow, and then the voice recording over the weekend. Okay.
Okay. Yeah.
All right, ladies.
Okay.
Thanks very
What's
much.
your email again, Joe?
Sorry.
What's your email address there again, Joe?
I'll tell
Send
you,
CV.
it is. I'll tell you now. If you look at the 1st of October, the second PowerPoint I sent you,
Okay.
it's on it. What I'll do now is I will put it up on WhatsApp later on. All right, in case you can't find it. It's Joan Lehan, CETB @McKeegan.ie. But look, I'll put it up. What I'll do is I'll send it off to you on the WhatsApp. All right.
Yeah.
Yeah. Right.
Okay.
Yeah. Thanks, John.
All right.
Okay.
Bye.
Okay.
Bye. Bye. Bye.
Thank you. Good night. Thank you.
Bye.
Bye, bye, bye. Good night.